Okay. Hello, you all. Nice to see you today. Great day for me, my birthday. So we have a new lecture about human rights today. For sure, some human rights that you know very well, that are related to the process, the criminal process, but also some other kind of process you will see. And our learning objectives today, as always, are three. First one, the history of the due process, specifically in criminal cases. We will see one battle there, very old battle. Then the due process principles. For sure, you will remember someone because you have in your careers a subject related to precisely to this, to the process. And finally, I will put you a test, a challenge to see if you know you learn very well the things that and how you learn that. So try to write the principles that we will see in this lecture. So at the end, you will be able to check, to double check all the things that you have. Well, so let's continue first with our first battle of today. That is here once again in Europe, many places, but specifically you will see war. But I want to remember first some idea that we considered in the last weeks. For sure, you will remember the Roman Empire, the whole Roman Empire when it began, its biggest part. You will remember also the fall of the Western Empire. No? Little by little, as you are seeing in your screens, well, the Roman Empire was expanded, and conquered more, and more or less at the first century was the biggest part between the first and second, and then was split in two, and the Western Roman fall, and after that Constantinople, but later, no? Later in 1453. You will remember more or less the attack of the south, the attack of the north. But today we will be focused in the year 1199. 1199. For sure you will remember one battle that was in the 15th century. And this is a little related to the 100 years war. So let's go ahead with this, and you will remember that after the falling of the empire, it was so important to find protection. That's why there were many cities with a big wall to protect the people of the city, and very incredible places, no? In the high of the cliff, for example, or precisely in the cliff and in the ocean or the river, as you can see at the left, or well, in many places, no? And also was so important at that time to have an agreement with the people with power, no? Because you realize that you alone cannot protect your family, your properties. So that was the time of the vassals, no? Of the knights too, the people that swear to one king, to one principal, to one lord, a landlord, well, but that will have more power to give more or less the life, the loyalty, and so many things. And the other will give you support, will help you well, against the invasions and many things, no? So, and that's why it was so important this, to have the keys of the city, as you can see here. No? It's incredible with the keys of the city, well, to be protected. It was more or less that time. So you remember, that's why I'm passing very fast this part, because we talk about this, about the loyalty, about the code, about the ideals, the goals that these people have at that time. Specifically, the painting at your right, you will see, well, I think that this could be the Second Crusade. Jerusalem, Holy Land, falls. There was an agreement between the most powerful countries of Europe to recover Jerusalem, to recover Holy Land. It was not possible in the Second Crusade. We will see what happened in the third one today. So it was quite important, no? Well, and that's why there was a code, kind of ethics of the kings, of the knights, to how to deal with many issues, with the king, with the emperor, and especially with love, with love. No? Be loyal to one kingdom, to one king, to one love. So I think that is great. That goals for any life, no? But this is a turning point today. No? It was also the time of the dungeons, no? And with a lot of problems there, because, well, a criminal will be treated so bad, so bad at that time. Probably will disappear, will disappear. And that is more or less the things that happened at that time. For example, if you have a family and you are going to your home, and suddenly you discover that there is no brother in your home, and you can begin to ask, well, what happened? What happened? Nobody knows. Nobody knows. Probably after a month, you will realize that he was in a dungeon, or is in a dungeon, still there, suffering probably torture by the guardians, by the knights of the king, well, and probably trying to receive some kind of confession about any crime. So it was so bad for the procedural law that time, no? And even an incredible dungeons, no? This was so typical at that time. Also in Rome, it's not just of the medieval times. It was exactly or even worse in Rome, even worse in Rome. I remember that I was in the dungeon or in the prison of St. Peter in Rome. You can visit today because it's a tourist point that you can visit. And it was more or less like this. It's a hall, and the people used to live in the hall. The room was not so big, probably the third part of this, more or less, yeah. And there were living 40 people with St. Peter, as we know. So it was incredible. Obviously, without light, the only light that they can receive from here incredible. And also with all the problems of sanitation, water, and many things. And they used to throw some food from here, but well, in an incredible conditions, not human, obviously, not a very decent conditions to live there. No? So it was so bad, and well, and for sure you know about these things because it was so popularized on television, on many places. The way of the process, no? You can see here, well, many things, no? A kind of torture, asking to the man to confess, well, was so incredible. I put here the not the worst one because you can find quite ugly things here, but I put just three that are another thing. I think well that was incredible, no? The principle of innocence. Well, nobody knows about that. Nobody knows about that. No, you are not innocent. You have to confess your crime. You have to confess. Today, self-incrimination is not even a valid evidence proof in the process. But at that time, it was it was the principal evidence. Incredible, the principal evidence. No? So the principle, by the way, who was the one who began to change this? Well, the Christian church, the Christian church. At that time, all the Christians were united. Um, the church realizing that there were many things that were not human accordingly to the faith. They introduced some principles, also the principle of innocence, and well, to protect the people, to do a fair process. After some centuries, the states copied more or less some of the principles that was in the law of the church of that time. Well, it was so interesting. And on the other hand, it was not just a problem of the how you get evidence. It was also many problems because at that time there was prison for the people that didn't pay the debts. So prison because debts, no? And that's why you can see in the graphic of the middle a guy with the rich man. I then asking, well, you have to pay me, and if not, you will be there your whole life. Incredible, no? Yes, Ali.
So does it mean then, if at all you never paid debt, then you'd suffer from criminal incarceration? So it would
Yeah,
suffer criminal punishment for no.
yeah. There were many kind of consequences, and depending of the time. I don't know if you have seen Bleak House, or you have read the
Yes.
yeah. For sure, you will remember the whole family living inside of a neighborhood that was for debtors that didn't pay. Do you remember that?
Yes, yes.
Okay. Yeah, well, so there were many consequences quite different depending on what time. Even today, there is something similar in the UK. There is something similar. No, if you don't pay, you don't have prison directly, but the judge could ask you to pay. And if you don't pay, you are against the order, you are not obeying the order of the judge. Imagine that. And that's why you can have also similar things. Incredible, not today. Oh, well, and obviously the kind of punishment, as you can see in the last graphic, were incredible. No, with that penalty in so ugly ways to pass away. No, so So that was the time. That was the time, and obviously, who was who had the worst part? Well, the poor people, the people that have no power, that are not noble, are not part of the royalty, nobility, or the church. Probably that probably will be the worst part for all these guys. No? So that was the time, also in which the new reigns, the new nationalities, the new nations began to build themselves. And I don't know if you remember this seal. This seal, we have seen that seal. This is the seal of the Angevins. We mentioned about the Plantagenet possessions in France and England in the 12th century. The same family will fight the later war. We will see them the 100 Years' War. But this is the very beginning. This is the very beginning in the 12th century. The very beginning of the 12th century, well, there was a family, some possessions, some connections of the family with France also. Well, but then there was troubles, and they asked to have some titles to be there, and that's why they decided to invade. You can see here, no, the vassals, no, and the royal domain, and well, many things. No, there is also a duchy here, and many things, and the county of Toulouse. Well, the Aquitaine, many places. It is quite interesting here, no? So that was, well, I will tell you another thing later. Also, that was also the time of the Crusades, as I told you. And one of the greatest kings of England was Richard Coeur de Lion, that is Richard Lionheart. Yeah, so powerful name for a so powerful king. Because he was a warrior. He was a warrior. All his life he passed fighting against so many people, principally against France, principally here, trying to conquer and to expand the empire, well, the kingdom at that time. It was the biggest possession of the family in France in the whole history of this, with this king. He was a warrior with a lot of success, and that is interesting because he spent the whole life, well, fighting, as I told you. Just 6 months. 6 months he was living in England. 6 months, and the other outside fighting against so many people. So that was quite interesting because, well, how you can maintain a war, asking money, asking people on England first, and then in other territories too. But it means that the people of England, well, the families probably were not so happy with this king on England, but it was the seal of Lionheart, the king. As you can see, a warrior in his horse. Well, and it's quite interesting because at one point, the Pope, Innocence III, realized, well, that we have to do something on Jerusalem because Jerusalem falls in the hands of the Turks, specifically with Saladin. in English. I think it's this. So was Holy Land, but Richard Lionheart realized that was so difficult to be there. Why? Because he was fighting against France, and if he goes to Holy Land, he will take all the troops of France going there, and what will happen? He will lose territories in Europe. Probably he will gain something there, but he will lose. So at the very beginning, he was not convinced, but at one point he talked with the people of France, with the king of France, the main one. They agree, well, let's go together. Let's go together with the Pope, because the Pope was asking, remember at that time, all Europe more or less was united with one faith. Realize, well, we have to help in this enterprise, the Pope. So they say, okay, let's go together, let's fight the Third Crusade. And that's what they did. I found this map. I think that is one of the best ones to explain how was the Third Crusade, but this in French. You can see in blue the Christian kingdoms around Europe, and the Orthodox in red, more or less, and in green the Islam, all the countries. You can see that also it was in Spain, some invasions of the Islam. So from London and from France and from Italy, there was planned the Third Crusade, and they go there trying to fight here, trying to take Jerusalem. You can see here Haifa. They designed the Third Crusade in the north and in the south of Jerusalem. In the north was a little success, but the great success in this Third Crusade was Haifa was acquired by this king specifically. He fought there and took Haifa, and he was trying then to conquer Jerusalem, but was not so possible. So he had to retreat, and he retreated to Jaffa. He then had less people, and Saladin attacked with so many people, more than the people of Richard Lionheart. But even though that he was able to maintain Haifa, and he was able to win that battle in Haifa with less people. But he realized, well, I will not be able to take Jerusalem. I can win this battle, but the war is so difficult. Now I have no people here. So what happened after that? He decided to talk with Saladin. And yes, he talked with him in 1192, and he got an agreement with the emperor of the Islam. There, he said, well, let us at least to be able to visit Holy Land. You will be the owner of this place, but let us visit freely. And he agreed. He agreed with that proposition, and that's why Richard decided, well, I have nothing more to do here. He departed the Holy Land on October 9 of 11 92 after this agreement. But when he departed, he decided, well, go by the continent to reach London, and in Austria, he was captured by Leopold V, the Duke. Why? Because it's incredible. Leopold V was thinking at that time that he was the murderer of his cousin. Well, and he captured him in this palace. Well, I don't know, it is a palace. At that time, it was the Burdenstein Castle in Austria. He was, so Richard Lionheart was a prisoner there. What he decided to do? Well, to negotiate with Leopold V, Duke of Austria. He said, well, I will pay you the sum that you are asking me for. And he sent some people to England asking 150,000 marks. At that time was a very big sum, a very big amount. And well, and he paid that, obviously. It was not so easy for the people of England with a king that was never on the island, was never, just 6 months in his life. Well, to cover that, to pay more taxes to rescue the king. And after that, it was incredible because he was fighting a little more in France. He died as a consequence of a wound in his breast by an arrow in France in 1199. So passed away fighting. That was, remember, the best conquer of England in France. His brother, let's talk about his brother. His brother is called John Lackland. Why? Because he never expected to have some piece of land at the beginning. He never expected to be a king, not to have power, not to have anything. But probably he had so many, well, aspirations in the goals in his life, and at the end of the life of Richard Lionheart, that was his brother, he tried to kill his brother to get the kingdom. So he was not able to do that. But soon after that, the king died in France, as I told you. No? So that was his time to be the king, no? Precisely, well, the same year of the death of his brother, 1199. And it was quite different, the situation there. He realized that I have to fight to maintain the land that my brother acquired and my people. So he decided, well, let's go to battle. And he left England. But remember, it was a whole century, the UK in battles, in wars, against so many people, also in Jerusalem, also here, so many money that they had to spend, so many taxes. There was not a good condition because, well, the winter and so many things in the UK. So he had a trouble, a very big trouble, because he was from the north, more or less, and he lived there in the north of France. There was an antique custom in many places of Europe that the king will nominate the bishops of the church. He was the competence, the faculty to nominate the bishops. The king, the political power, was able to nominate the bishops. But that custom, little by little, disappeared. But he was from a part of France that it was still there, the custom. So at one point, there was a lack of the bishop of Canterbury, and there was a little discussion between the Holy See and the king, John Lackland, and he decided, well, I will nominate someone. And the Pope says, no, you cannot not nominate that because I have the power. No, I have the power. And it was a problem about who has the power. At the end, he was able to ordain the people of the UK, the people there. And so the Pope decided to excommunicate the king and the whole England and to ban the possibilities of receive sacraments for some time. Well, there was an issue, a very big issue with England. As you can see, at that time, well, the whole Europe was well, Christian, only one faith. And it means that the king lost there some good reputation, no? Because he was against the Pope, and the people, the common citizen, was not able to receive the sacrament and so many things. At the end, well, there was an agreement between them, but after some time, even years. So that was the problem with Pope Innocent. Well, so with these two things, asking money, new battles, the king is outside of the country once again, is against the Pope, is, well, there was so many issues. And the worst is this, that the battles in France began to lose all of them. And there was an invasion of the French people. Well, it was not so good for the fame, for the good name, reputation of John Lackland. So you can imagine how happy were the people of England with this new king. After a big king, a lion heart, and not so powerful king asking money, more money to pay to defend. It was one of the coins of his kingdom. You can see there, his face more or less is more or less similar. I think so, more or less. But in any case, after losing some battles, the king decided, well, I have to go back to the island. That the big issue, the big problem of his life. Because in the island, there were so many angry people, so many landlords that decided, well, we will not pay it again. All the battles of the king. Especially a landlord called Robert Fitzwalter decided, well, let's unite all the troops of the landlords and let's go to fight against the king. At the very beginning, they tried to talk both parties, the archbishops of Canterbury, Langton, Remember, it was an issue who will be the Archbishop of London. Both parties decided here to talk. And London, well, they decide, well, it will be impossible to maintain because they want to kill the king, and the king want to kill all these people. So let's write a letter to with some kind of agreement, some kind of concessions between the parties, compromises. Well, it means many things. So after talking, both parties decided to meet here in Rooney Mead. I don't know if you have heard about this. It's quite close to Windsor. And this is the place in which the Carta Magna, the great charter of rights of England, was signed. So this is what once again Fitzwater and the landlord in the place to sign the Carta Magna. This is the new Carta Magna, as you can see. Incredible, no? This one of the painting, very antique, more or less. And he, the king, seeing that, well, I cannot do anything with the approval of these people, decide, well, I will sign this letter and I will give whatever they want, and let's see what happens after that. That is quite interesting. Because, why? Because there are many interpretations of this act. Many people used to say, no, it's the first constitution of the world. Well, probably, well, the Greeks also had properly a constitution. But at that time, it was not properly a constitution. There were many letters of the kings, especially in Spain, 1 century before that. For example, I will mention you someone. For example, in Zaragoza in 1115, in Calatayud in 1120, in Burgos, Spain, even in 1073, and even in Leon in 1020. So even 2 centuries before, there were these kind of letters in Spain. So but this will be a little different. So remember, at that time was the conception, all the people are under the law except the king. The king is not is not under the law because he can put another kind of law. And these kind of letters, they decide, well, I will respect my letter, the thing that I'm writing here, I will respect. So it was the same thing that happened in some other kings, especially in Spain 2 centuries before in Leon. So, but this is quite interesting. Finally, he signed this letter, the Carta Magna, the Great Charter of Rights, that was so famous. Many people used to say that was as I told you, the first constitution, the beginning of the constitutional movement, because also the kingdom is under the law here. Well, you can believe whatever you want, and it's quite interesting for the history of constitutional law. And I think that at the very beginning was not a constitution, this or something like that. But after that, it will be. I will explain why. but at the very beginning was the usual letter of a king. What kind of provisions we have there? Well, a lot of provisions. It's a very long letter. Yeah. So the draft of the Archbishop of Canterbury, Stephen Langton, well, decided, well, let's include some rights of the church. So the king here promised the protection of the church rights. First thing, if he was the drafter of the letter, he included that. Then there was a lot of protections for the barons from illegal imprisonment. Remember, what happened if you don't pay at that time? Taxes to fund the war. Well, you will be on jail and you will suffer torture and so many things, no, at that time. So what the second thing? Well, I don't pay taxes. Well, it is some protection. Please give me some protections here, no? No, at least from illegal imprisonment. Then, obviously, what happened if I'm in prison? Well, at least give me a swift justice, speed justice, no? So they asked their an access to swift justice. And also many limitations on feudal payments to the crown. That was the principal issue, as I told you, no? To be implemented through a council of 25 barons. And so it is quite interesting because it's the beginning of the parliament. After 1 century or later, this council will be the parliament. It will be the parliament. And soon it will be split in two, the lower and the higher house, as you know, and many other things. But this was the very beginning of this. So it is interesting because we have now, well, many clauses of the Carta Magna, of the Great Charter, are not longer in force. But 3 of them, yes, still today are in force. 3 of them. This I will put you the 3 that are still in force. The first one. First, I'm reading the Carta Magna. We have granted to God, and by this our present charter, have confirmed for us and our heirs forever that the Church of England shall be free and shall have all her whole rights and liberties inviolate. So you can see here, well, this is the phrase that the Archbishop Langton include in the Carta Magna. Because of all the problems with the Pope, so you have to respect our liberties. You cannot nominate our authorities and many things. No, the church will be free, shall be free, with the whole rights protected. Well, that was the second that this is still in force from that time. The city of London shall have all the liberties of customs which it had been used to have. Moreover, we will grant that all the cities, ports, towns, and the bounds of the 5 ports, as with all other ports, shall have all their liberties and free customs. Well, there is a protection of the rights of the barons, of the people, the city too, as you can see here, no? More or less the idea it was. And for the lecture of today, the most important one was this, that this is still in force. No free man shall be taken or imprisoned. or be disseised of his freehold or liberties or free customs, or be outlawed or exiled, or any otherwise destroyed, nor will be not pass upon him, nor condemn him, but by lawful judgment of his peers, or by the law of the land. We will sell no man, we will not deny or defer to any man either justice or right. So this is quite interesting. You can see so many rules of the due process today, so many principles here. No? Now, you have to read it carefully, and you have to answer me this question. Is there, in the last provision, the habeas corpus? First, you know what is the habeas corpus or not? Don't you? Any one of you? Have you heard about the habeas corpus? No? I think that you had some lectures of Can you hear me? Can you see me?
Yes.
Perfect. So I was asking you if you know more or less what is the habeas corpus. You have studied that. Don't you? So can you first, can you tell me, yes, Ali?
It's a form of doctrine in law whereby you can actually report an unlawful detention, violation of human rights, and imprisonment to a court and request that the court order the custodian of the person protection by a prison official to bring the prisoner to court to access justice.
Perfect. Do you know what the words mean? Habeas and corpus.
The etymology.
Yeah.
No, I don't know the etymology, but I know the functionality of
Okay.
the word.
Blake. Yes. Do you know?
Produce the body.
Yeah. So in English it's quite similar. In other languages it's not so quite similar. Corpus is so easy, the body. No? And habeas is have, to have the body. Why? Why? Because remember the story. No? What happened at that time? Well, you go to your home, and then in your home you realize that there is no brother there. Well, and you begin to ask to someone, and nobody knows, have no idea at all what happened with your brother. So at the end, after 1 month, you realize that, well, probably is in the dungeons of the kingdom. Probably is tortured there, and so many things. So habeas means, well, it's a specific action to ask, for example, the kingdom of the principal or the governor is quite different in each place today, but to ask to some justice, speed justice in front of the body. First, we have to have the body, in front of us, and then you will well, say if the prison is good or not, and the process was fulfilled all the requirements or not. That is why habeas corpus, to have the body, because we need the body to see him, to judge in front of the body in a public way. So not in a private dungeon. So that is the meaning. Then I will repeat my question here. Is there in the clause 29 the habeas corpus action, the habeas corpus process, or not? What do you think? You need time to read, I understand that. Is there? Isn't it? Yes, Ali.
In relation to the process of the habeas corpus, is there a process of the habeas corpus?
In this clause, yes.
Yes, because the clause says that no one shall be taken or imprisoned or be disseized or exiled or any otherwise destroyed. And will sell to no man, will not deny any man either justice or right. It essentially means that justice shall not be denied to any individual, and individuals shall be allowed, or the court shall facilitate accessibility to justice for such individuals for their own liberty.
Okay, I don't know if there is another opinion about this. Well, I don't think so. However, the people of the kingdom at that time, especially in the United States now, the colonies of the United States at that time, well, later, will believe that in this clause 29, it is the habeas corpus. But nowadays, people used to say, no, it was not. Why? Because properly, the habeas corpus is a speed action. It's a speed action when you ask to have the body in front of yourself, and then you can judge in that precisely moment in front of yourself and of the authority of the judge or the king, whatever you want. But it means a direct process, a direct speed process and a speed action. And it is properly not here. You can find here just some guarantees. Also, you can find here the grounds, the principles in which the habeas corpus will be based, will be grounded, but not properly that speed action. So you can think whatever you want. You can also, the people of the colonies of the United States believe that here is the habeas corpus, and it was not precisely the same. So, as you can see, there were many clauses in which the king was obliged to fulfill. And also the barons were obliged to fulfill, to give some peace, to well, many things. This is quite also interesting. One other clause, that's the king signed. And if we, or in our absence, remember, Lionheart was just 6 months in his kingdom in England, or in our absence abroad, the Chief Justice had not corrected the transgression with 40 days, reckoned from the day on which the offense was declared to us, or to the Chief Justice if we are out of the realm. The 4 barons mentioned before shall refer the matter to the rest of the 25 barons. Well, and they will take measures, more or less. So many people used to see in this clause the principle of the rule of law that will apply to all, not just to the nobility, but also to the king, and also to the church, and also to everyone. More or less, this is the basis of the new constitutional state. And it was so important, this clause, in the history, because after signing that, well, they decided, well, we have some peace, but at the end of the day, any peace, any peace, because no part fulfill their commitment. Soon after that, that was the beginning of the First Barons' War, the First Barons' War between the landlords and the king. It was principally the leaders of the landlords, Robert Fitzpatrick, and on the other hand, you will see the king. And the king decided to persecute them, the barons, was going here, and also the others will to attack some buildings of the king. And what happened finally? Well, that between them, John decided also to retake the Battle of Normandy in 1214. Why? Because, well, he lost that and he said, well, I have the titles here. It was my place. His family was related to that part, and so many things. So at the end, after so many battles, also on England, on France, he suffered an illness, and he passed away in 1216. So soon after the signing the Carta Magna, that was in force some minutes, not so long, some minutes. And even, well, was nullified for many people. This is one of the paintings of the First Barons' Battle. That was that's 2 years, almost 3, between 1215 and 1217. And after that, the king died. The king was died. Well, but it was so interesting. Why? Because after that, well, so many people will remember the Carta Magna, the Great Charter. The Great Charter, they will apply the new lords, the new king will ask, well, we have discussed that with the king. And the king signed that. And after a century, almost 50 letters of the kings and agreements and many things will remember the Carta Magna, and the king, little by little, by a kind of custom and a kind of new concept that is arising in that century, will realize, I have to respect the letter of the Carta Magna. So many constitutionalist jurists used to say now that at the very beginning, the Carta Magna, the Great Charter, was not properly a constitution, but after 1 century was a constitution, because after 1 century later, all the people of England, even the king, realized that they are binded to the things that were written in the Carta Magna. So this is interesting, little by little in the conscience, and still is in force today. You can see here the tomb of the king, John Lackland, the seal here, and also the face, no? Because at that time were not so good paintings. More or less the thing that we have is specifically is from the tomb. More or less we realize how the people were at that time seeing the terms today. No? It's quite interesting because centuries before that, little by little, all the rules that were there in the Carta Magna were developed. And as I told you, in the colonies and also on England, the Carta Magna was a big rule. It was recognized and protected by the liberty of individual Englishmen made the king subject to the common law. The king is subjected to the common law. This is a crucial idea, formed the original on the trial by jury system and acknowledged the ancient origins of the parliament. Because of the Carta Magna and this ancient constitution, an English monarch was unable to alter long-standing customs. So, one important point in the history of the law in the island was, for sure you will remember, Edward Coke, a great judge, a judge of the common law. Remember that at that time there were two kinds of judges. One, the judge of the king, and another, the judge of the common law on England. No? This is quite interesting. When Montesquieu brought the spirit of the law, he proposed, well, let's split the power of a kingdom in, he said, not in three, in two, which the power of the king and the power of the parliament. The parliament, not the judge, because he saw that on England. He was a tourist. He read, oh wow, here in England are two different powers, so it's good to have a division of power. And the power of the king, he decided, well, you can divide also that, but on the king, no? And there you will find the judges, the courts. So it was quite interesting because he was a judge of the common law. As a judge of the common law, remember the thing that we saw in jurisprudence, no? At the very beginning was, well, the sense of the people that they have in their mind. After that, little by little, because you cannot contradict yourself, there was a little by little, one judgment and another, and now the common law is a set of judgments. But at the very beginning, it was not. It was quite different. So, he was a judge of the common law, and also with an incredible reputation in England. That's why he was nominated as a parliamentarian many times, because the king also destituted him, and he once again was elected and then elected again. Incredible. No? He had many fights with the king because he had a doctrine. No? First, he used the Carta Magna to ask many things to the king and to say that he has no power to do some kind of things, even his marriage. Incredible. Well, and he had an incredible doctrine of the three courts. I don't know if you have heard about that. He was absolutely a judge, absolutely. And he believed that all things in the kingdom were courts. The court of the king, the court of the parliament, the court of the judge of the common law, of the common tree. But the interesting part here is that he said, well, the king can put new rules, the parliament can put, but the only one that cannot change the rules are the judge of the common law. And that's why, which will be the principal? Well, the principal will be the courts of the common law, because they cannot change the laws. That was so incredible for that time. After that, you will see the judicial revision many centuries later in the United States, and the whole world will follow the doctrine of the judicial revision of the laws. But at that time was quite clever doctrine of code. So he based his doctrine on the Carta Magna, as you can see, no? And also, well, there are something that is above the king, above the parliament, over them, and that's why we have to fulfill all this kind of thing. Little by little, the habeas corpus was improved, and there was a first habeas corpus act in 1640 that suffered and included many other things after some years. In 1679, the new king, Charles II, included so many things, so many guarantees to the Habeas Corpus Act, as you can see here, one paper of that time, publishing more or less Habeas Corpus Act. And after that, it had several revisions, for example, in 1803, 04, 16, 62, but more or less all of them based, or always remembering the Carta Magna, no? the principles of the Carta Magna. And it's quite interesting because little by little in all the world, not just in the island, but in the whole world, people used to include now in the first and the legislation, and then in many constitutions, the habeas corpus. The habeas corpus, that as I told you, is a speed action to people that we believe that well, are not in prison because in good conditions. So now you can find a lot of habeas corpus. For example, first, asking to give a proper judgment. Second, to see if the conditions of the prison are good, or the imprisonment also. No? Two things, the prison and the imprisonment. So it could be possible, for example, that it was not the due process, it violates the principle of innocence, and the imprisonment was against the law. So you can sue an habeas corpus and ask, well, let's have the body and judge in front of all people and not by torture, obviously. And second, also, a person that was properly without due process on prison, now in many places you can ask the habeas corpus because the prison has not the conditions to a human life. And, I mentioned you some cases in other lectures, no? Prison with a lot of people, very crowded. So living in a very bad conditions with poor health and so many things, but you can ask also in many countries the habeas corpus to take that guy and to put in a safer place. So, and also there is a new additions now that was more or less related to the origin of the habeas corpus, that if you don't know, you have no idea about some guy, you can just say, well, I will fill my habeas corpus to see if the Navy or if the military captain give me some information about my relatives. So, as you can see, little by little, around the world, also in the UK, the habeas corpus was improved to give to all people a speed action to protect principally the life and the physical freedom and also the health of the people that are accused or processed or imprisoned. Now, three things possible. No? So you can see that there is a lot of things now with the habeas corpus, and not just with one thing. Another important issue, specifically for these kind of things, was this. I don't know if you remember what it was. We, the people of the United States of America, well, the Constitution of the United States of America, issued in 1787, you remember. Then, remember, the people of the colonies, of the 13 colonies, believed that in the Carta Magna was the habeas corpus. They decided to include this in the new laws, in the new constitution. So you can find in the Article 1 of the Constitution of the United States of America, the privilege of the breed, now it's breed, at the beginning it was not, breed of habeas corpus shall not be suspended unless when it causes of rebellion or invasion the public safety may require it. So it is quite important. Look at this again, look at this. Well, there is in the Constitution now a confirmation that there is a right related to the habeas corpus, no, and specifically right, and specifically action. But there is a word, unless when in causes of rebellion or invasion or the public safety, and three things. When it happens, well, there will be no right to habeas corpus, not. And today, these kind of phrases are quite strange. Probably will not pass the human rights standards in this field, because most of the crimes against life, freedom, and health are specifically in state of emergency, in curfews, in time of invasion, rebellion, or problems of public safety. So this is quite interesting. But the Constitution says a little more. In the first amendments of the United States Constitution, they add, this is the very beginning of the constitutional movement. This is the first clause in a codified constitution that talks about this. In the 9th amendment, it says, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Well, there is a balance between both, as you can see. It will be so important. It will be so important. Why? Because there are many issues here. We will see two cases, and you will realize why this was so important to read both clauses of the Constitution. Now, one question. I don't know if you have heard about this phrase. Probably yes, nulla pena sine lege. My question here, who said that? What do you think? Who said that? Many people probably will try to find someone on the internet, especially if I give 1 point to the final examination. You send me the name. Nobody knows. Nobody can try. Well, okay, a clue. Well, a very old guy. Yes, Ali.
Just a trial. So if at all something isn't pronounced to be prohibited in the law, then no punishment shall be instituted against you through the principle of nulla poena sine lege.
Yeah. So, nulla pena sine lege, it means there is no punishment without law. Okay. And who was the guy that mentioned that? The original guy. A clue. Do you know who is this guy? Do you remember? We have seen him time ago on jurisprudence. I think that one, well, I don't know, here in human rights. This is Ulpian. In the year 228, he wrote in the digest something similar. He was not probably the author of this phrase, but more or less the idea. You cannot punish anyone if there is no law. You need the law to punish people, not because the judge, they say, well, this is a bad guy, he should be on jail. No, that is, you need a law that is punish, and the specific punish is the prison. No? But he was not the author of that. After several centuries, there was a great criminalist jurist called Beccaria. Beccaria probably is the most famous one nowadays, on criminal law. And he said, well, he developed the doctrine of nulla pena sine lege. We need the law to punish some guy. But he was not the ones who brought exactly that. So once again, who was the first to mention with those words? This guy. Don't you know who is him? Well, it's not so easy. Von Feuerbach. Von Feuerbach. You can see it in 1801. He said, his phrase is this: nullum crimen nulla pena sine praevia lege penali. That is a little more precise. Nullum crimen, there is no crime. Nulla pena, there is no punishment. Sine, without that. Previa lege penali, previous penal law. Because obviously, the law can if you are the king and you want to punish some guy and there is no law, what you will do? Well, I will write the law and I will say, well, this is a new crime and you should be on prison. So no, Feuerbach said previous, no. Previous, you have previous of what? Of the act. I think that you really understand very well this. Another question now. You can you more requirements to punish people? You can first nulla pena sine lege. Here you can add previous, and I don't know if you can add any other. Think about that. The Spanish court used to put this phrase in their judgments. Nullum crimen nulla pena sine lege penali previa. Now is exactly the same for your, but they add stricta et scripta. Stricta et scripta. Stricta, strict. Yeah, if you need to one interpretation, you cannot give to the criminal law a broad, a wide interpretation. No, it should be strict. We have seen that on jurisprudence. Probably you have seen that also in criminal law. I don't know if you have that subject, or you will have, I don't know. But previous and with a strict interpretation. And also they add scripta. Should be not in the custom, not in the conscience, no, should be written, a written law. And a strict interpretation and a written law. Don't you want to add any other requirement to adjust punishment to criminalize someone? Can you imagine another requirement? There is a lot. There is a lot. Yes, Elvis.
Just thinking out loud, the will of the people to actually be bound by that law.
The will of the people is expressed in the laws, more or less. Okay. Another? Thomas Aquinas said, nulla pena sine iudicio. There is no punishment without a trial, a judge. He said, ex iudicio lex punit. By the trial, the law punish people, criminalize people. That is quite interesting, no? You need not just the law and the previous law and the written law and a strict interpretation, but also a good and fair process, a just process. We found also in the Roman law new requirements, new. Inaudita causa quenquam damnari equitas ratio non patitur. So it means no one can be punished more or less without being heard in court, inaudita causa. Well, if you are not since someone don't hear the accused, the guy, no one can punish that guy. So you have the right to self-defense. So that is so important. The legitimate defense. Also, you have to hear the parties. So another requirement. No, now can you add any other any other requirement? We are building more or less the principle, the whole principle. It's better to try to think and to resolve in your mind more than to memorize just the thing that I'm saying, no? Because you will be able to get more. This is the whole principle. Don't worry if you can't do that because all these kind of things you have in the code. In the code. So more or less, I think that this is the standard today. Nullum crimen sine iudicio praevio. There is no crime without previous trial. sine defensione, without defense, sine, and this is new, factis, ex actis et probatis. Without facts, well, all the things, the ex actis et probatis. Probatis is proved. You need evidence. Without evidence, you cannot punish anyone. And not just well, some evidence, but the evidence in the process, ex actis, in the files of the process. And you have to give all the evidence to the judge in order the judge can accuse and punish someone. And finally, sine sententia, without judgment. Without judgment, you cannot put anyone on jail. And you have to communicate, to inform, to report about the decision of the judge to the guy. Okay, so this is the final statement. Okay, so let's put two little cases. I don't know if you know where it is. It's in the Caribbean. In the Caribbean, in a big island, the biggest island of the Caribbean is, well, this is in the south of Cuba. And what happened there? That there was a little battle between the United States and the communist government of Cuba. They were able to put there a base to control more or less the area. And this is Guantanamo. In Guantanamo Bay, the United States have a base to defend the country against the communism. In the Cold War, it was an issue. It was the risk of many missiles from Russia, especially that were helping Cuba from to the problem of the missiles of Cuba. Well, because it was so close to the United States. That's why they decided to put there a base. But now the problem is that it's not properly in the country. And in the country you have all the laws, the habeas corpus, the protection, the guarantees, the due process. But in this island it's too far. And there are many prisoners. Many prisoners well, with a lot of bad things. No? In contrast to the trials of other persons detained during an armed conflict, the Guantanamo detainees are not tried before courts martial following the procedure of the Uniform Code of Military Justice. That is the common code that they use in wartime. So they decide this is a base for a wartime, but even that code will not work in that island. There is a prison also for terrorists, for example, or suspected of terrorism. So they decide in another way, not using the Uniform Code, and they use a commission, a military commission that consists of one military judge and at least 5 military officers. Well, more or less, you can find more or less something similar in the government of the President Roosevelt during the World War II. So the Guantanamo detainees have only a restricted right to representation by counsel since a civilian, non-military defense counsel. It's incredible, no? And all the information of the process is classified as secret, a secret process still today, incredible, no? Well, the majority of the people there, well, they have no a regular process, not a due process. Probably people used to say some tortures and self-incrimination and involuntary statements, hearsay evidence also admitted in this kind of thing. But more or less it's interesting because as you realize they treat them not as a citizens but as a prisoners of war, using specifically, you will remember the clause of the Constitution that says, well, the Habeas Corpus Act, you can ask that right, but not when there is a security issues, but not on invasions, but not on war. On war, you will apply another kind of legislation. And it was used even more after the attack of the Twin Towers on September 11, time ago. So you can realize that there are still so many processes here. Obviously, I think that in many things, the United States is better than many other countries, no? I think that in China, well, there is a lot of stuff there, a lot of stuff, no? People judged by administrative functionaries, no? It's quite developed, the administrative law there to punish people, no? In so many ways. So, and in other parts, the Soviets, well, in Korea and many other places. Another case. This is another case that it is interesting. This is a case of Otman, a guy with a lot of problems that one day decided to fled from his country, Jordan, in 1993. He was suspected of terrorism. Imagine that. Imagine that he was trying to be in the UK, and the immigration authorities found him. Imagine that you are an officer of the immigration authorities of the UK, and you realize, well, the guy that is in front of you seems to be a terrorist. This more or less after the Twin Towers attack, and you have so many attacks in the world of terrorists, in your mind, in the newspapers, so, and you have the power to not to let him to and be in your country. What you will do? What you will do? Probably you have a report, and someone of an international office is calling you. This is a terrorist is suspected to be. So what happened? The UK had the opportunity to deport him to Jordan, but there was a risk that in Jordan, they knew that authorities will use torture against him. He fled. Remember, he fled from Jordan during his retrial. He was escaping from justice. He said, well, it's too much of the thing that I have in my country. I have to escape from my country. So what you will do? My question, what the immigration authorities should do with this guy suspected of terrorism, also because the country wanted to retrial him, that guy. will you allow to enter into your country, or you will just say, well, go back to your country? What you will do? Will you do? No idea. You have two possibilities, to admit or not. And why? I don't know. Julien, what do you think about? Or Helen? Are you there? I will consider the people that participate in the. So, finally, the UK decided to deport him to Jordan. And this is the interesting thing, that the case was new by the European Court on Human Rights. They ruled that his deportation violated the Article 6 of the European Convention of Human Rights. That is about precisely to the right to fair trial. So it was interesting. One of the statements of the judgment of the decision of the European Court say it is quite interesting. No legal system based upon the rule of law can countenance the admission of such evidence, however reliable. It is interesting. They realize that there was some evidence that more or less reliable that this guy is a terrorist, which has been obtained by such a barbaric practice of torture. So the trial process is a cornerstone of the rule of law. Cornerstone. Torture evidence damage irreparably that process. It substitutes force for the rule of law and taints the reputation of any court that admits it. Torture evidence is excluded to protect the integrity of the trial process and ultimately the rule of law itself. That is quite interesting. So if you have the risk that doing that action that probably in another circumstances could be quite legal, quite fair, but if there is a risk for this guy to suffer torture, you cannot take that risk. You have to accept a terrorist in your country, and probably you can put him in prison if there is a reliable evidence to process in some way. So it is not so easy, as you can see, to admit a terrorist in your country by decision of the European Court. No, well, it's not so easy many times. It's not so easy. But on the other hand, you have all people have the right not to be tortured. So this was my last case, and we can do a break now, and then we will see the principles of due process, not just of the process related to criminal law, but in general. So you have 10 minutes now. Let's continue with our lecture. We have seen something about the history of the due process, but specifically in criminal law. And now we will see not just in the criminal procedure, but all kind of process of legal process and the principles of the due process. So I think that you that are in the third year have some idea about which kind of principles should govern the due process. So that's why my first question here is, first, what is a process? Because remember, with a notion, we will get the aims and we will get the principles too. And my second question is about the aims of the process, no? What are four procedural laws or the process, the judicial process? What do you think about it? Can you, I know that you have a subject about this kind of things, one or two even. So probably you will be able to answer me these two easy questions. What is a process? What do you think? Yes, Ali.
Am I answering what a judicial process is?
Yeah.
So a judicial process is an interconnection of legal procedures that are being used by the court as an authority for the dispensation of justice.
For the dispensation of justice. Okay, and what about the procedural laws and the goals, the aims, what they are for? Didn't you? Yes.
To facilitate and act as mediums for the dispensation of justice.
Dispensation of justice. Well, I think that more or less yes, obviously there is a lot of reasons. I will add something. I would add, for example, first is, well, you mentioned more or less, but it's an order, an orderly set of acts, actions, and decisions. Yes. Yeah, series of steps that must be taken in order to fulfill mandatory requirements. Yeah, that's good. And this is more or less the principal idea. But it's not just a set of acts, action, decisions, but is the principal thing, as always, is the aim. Is the aim, no? And what is the principal aim? Well, provided for an impartial judge, to find the rule imperative, the truth of what is just. So to make justice, you need first to know what is the just thing. What is fair here and now? What is fair? And you discover that many things in the procedural law are specifically for that, for discover what is true. For example, why is evidence have the whole rules of evidence? Because we have to discover what is the truth of the facts and what is the truth of the law here and now. So that is the first interesting and quite important thing. And then obviously what is just, truly just, in one specific case, on a matter submitted to his trial, after having listened the parties, all of them, that we saw in the principle, no? Audita part and should be here, the principle of legitimate defense, and having collected sufficient evidence, no? There is no process without proofs. Okay. So my next question, that I think that probably you have some idea of this, is what kind of truth should seek? This is an important question and will help you so much for the test that we will do today. So there are two kinds of trust, a material and a formal trust. What is the material trust? The reality, no? Or the formal. The formal is just the truth that you can find in the files of the process and the evidence that the parties give, but not outside. For example, if you don't have in the process any evidence of that some guy is the criminal, you cannot condemn him, even in the case that he is the criminal and the judge know because he has some other source that is not in the process. So my question, my second question here, that is quite important, and there is a lot of issues in this question, is what kind of truth should the judge seek? The material, the reality, or the formal? Just it's enough to have some the files of the process to decide the case. What do you think? Okay, the material, but why, Effie?
I'm not very sure, but I think.
Try.
Okay. Just sometimes the facts could point to one thing, but do not necessarily mean that the action done was particularly a fault. For instance, if you look at murder, sometimes just looking at the fact that somebody died doesn't mean that you've arrived at the right decision, because it could have been in self-defense, which changes the decision at the end, or it could be it wasn't intentional, so it's actually manslaughter and not murder. So just looking at the facts, sometimes I feel like it's better to look at the whole thing as a whole. So look at it holistically, yeah.
Okay, another one to give your opinion. I will give you a clue to resolve that. There could be many kinds, many types of process, not just criminal process. What do you think? At least as an ideal, as a goal to achieve, the material, the reality is the base of all things. No, we cannot condemn who was not the criminal, and we should condemn the criminal. No, the criminal in the reality, or the innocent in the reality. First, second, but there are so many cases that are not so important, or well, important always, but you can negotiate in so many matters related to the law. For example, you cannot negotiate that the person that should be in prison should be the criminal. No, you cannot, and not the innocent guy. It is not negotiable. You cannot deal with that. But for example, if I have a problem about a debt, about 2,000 shillings, it's not so much. Seems to be not so much. And someone of you sue me, file me, asking, oh, the professor, I gave the professor 2,000 shillings and he never paid me. You asked to the judge, and I realized that this, well, is too tedious, too boring to go to the court just for 2,000 shillings. And I decided, well, I never will go. And if the judge decide, well, I will pay. Yeah, this is an available matter. I can't decide anything about my money. And if I'm not going to the process, it's because I'm not so interested in that process. Probably in that process, the judge can have a judgment against me because there could be some kind of proofs, and there is a formal truth that I'm the debtor. But in the reality, probably I'm not. But I decided, well, not to be there and not to defend myself. So when the conclusion, when the matter is an available matter that you can negotiate, that is in your disposition, probably it is enough the formal truth. Because if the people don't want to give the evidence, probably, well, they are dealing with their things. But on the other hand, when there are not available matters, you cannot dispose of that. Well, you need the real truth. So as Effie said, but just in those cases. For example, if I'm not your father, well, you cannot sue me and say, well, you are my father. Obviously, because this is not a matter of negotiation. Yeah, and the judge can only say, that is the father based on evidence. On the other hand, what happened in criminal process? Criminal process, the judge can only put someone in jail if he has evidence that is related to the material or real truth. Yeah, and a certainty. He is guilty. And what happened if he has not that kind of proof, that kind of evidence? He will not be able to punish anyone. The decision should be, there is no proof. There is no proof. And this also is a certainty about what's happened in the reality. There is no proof in the process about the guiltiness of this guy. Okay, so in the criminal process and in the relationship things and all the things that are not available or at disposition of the people, you need the real truth. So, and if you discover that the reality was different, you can nullify the process or ask some compensation. Okay, this is quite interesting. Distinguish these two kind of process. This will help you for the test that we will do at the end. So let's go now with the principal question of this second part of the lecture. What kind of principles govern the process? For sure, you will remember at least 5. The other lecturer remembered, I think, 10 of the 30 principles that I will put you on your screen. In your screen. Any principle? Try to remember at least 5 principles of the process. We mentioned at least one, nulla pena sine lege. There is no punishment without law. This is a principle. But can you remember any other principle of the process that should govern, that you studied? Because it is the same in the whole world. In the whole world is the same. The other course, remember 10. We talk about here some other principles. For example, there is a need of legitimate defense. There is a second one, mentioned 2. I mentioned many others in this lecture, but try to remember, because in this way it will be so easy to do the test and to remember and to answer the quizzes. Yes, Ali.
A just and fair process of the law.
Just fair
iudicio.
process of the law, perfect. That is a third principle. Okay. 3, fair process. What it means? Well, it means so many things. Yes.
Strict interpretation of the law.
Strict interpretation of the law. Which law?
The written law. Strict interpretation of the written law.
Of the written, well, not of all of the written law. Specifically of criminal law, yes.
Yes.
Many times of procedural law, but not civil or commercial law. In this case, there is no need to strict interpretation. Another principle. Well, yes.
No punishment without no crime without any legal punishment.
Yeah, that is in the first one that I mentioned. Nulla pena sine lege sine. Yeah. Lenny said impartiality of the judge. That was mentioned in this lecture, and yes, this is the 4th one. Yeah. Okay, we have 4 now. Try to be better than the other course. We have 4 now. Impartiality. Yes.
No crime without facts and evidence in the due process of the law.
Well, okay, this is the whole principle, the long one that we mentioned here. Yeah. Well, 1 minute more. Try to remember, try to check your notes. This is because there will be the same. But here you will see the panorama, the horizon of the principles. So there are more than 30, but I will put you the principles one here. And I will divide in 3 groups. First group will be related to the essence of the process. The second group will be related to the administrative management of the process. And the third one will be related to persons and property. Well, this is a little more difficult, the last set of principles, but not so that much. You will realize that it's so easy. Let's begin with the principles related to the essence of the process. What is the essence first? Well, the essence, you can have the essence of the things seen the notion. If you remember the notion that we gave, you will discover in the same notion, well, at least 4 or 5 of those principles. I don't know if you remember, but let's try to remember, no? I don't know if you brought anything about that. In any case, let's see. The first principle is related specifically to the aim of the process. As I told you, the aim of the process first is to discover the truth. Not properly well, is related to make justice, but probably there will be another people that will take the judgment, will execute the judgment. But probably the first aim is to get the truth and to declare in a judgment what is the true just. Yeah, not the false just, because any judicial error should be compensated. So the process, its subjects, acts, and elements exist to find the truth about the truth and what is just, what is fair, and in an imperative way. Second, the principle of justice. Justice will not be sacrificed for the non-observance of mere formalities. This is quite interesting. I copied in the code some phrase of your constitution of Kenya, because I think that was so clear there. No? There are minimum formalities, minimum requirements. Well, those requirements hinder the realization of justice. Well, you have not to follow them, the principle of justice. No? The principles of due process, fair process, and it's also attached to the principle of legality. To that aim, both justice and the truth, the process must be followed fairly. What it means fairly, well, it could be many things, but also as provided by law, by the law. Okay, more or less. Both here you are 2 principles, both of them related, linked, connected. Fourth one, the principle of legal security, the certainty of the law. You have to follow the law, and the law should be clear. The law itself should be clear and give you some kind of certainty, the stages of the elements, the rights of each party, and the rights about the next stage, if you can appeal or not, all of them should be clear in the law, and we have some certainty that the law will not change every day because it will be complicated. Then the principle that we mentioned, Nullum crimen sine iudicio praevio, sine prova, without judgment, without proof, without a sentence, a judgment, without the law, without many other things. All these kind of things that we have seen in the first part of this lecture, you can put it here. Next one, the principle of impartiality of the judge. Well, so Lenny told us, remember that. And I don't know if you see that all these principles are related to the notion of process. When we define what is a process, we said, well, is a process in order to the impartial judge to give some decision about, etc. So it's here, no? There is no process with a judge quite entangled with some party, obviously, no? Because no one can be the judge and also the party in the same process, obviously, no? So these are clear. I think that you understand very well these kind of things, no? Presumption of innocence, we talked about that. As long as his guilt is not proven and declared in a final judgment after the process. The principle of the legitimate defense also, no? The guilt should be proven and declared in a judgment after the process. All of them are related to the due process and to the reality. So those are the principles related to the essence. What about the principles of the management of the project, the administrative principles? Well, there are many. There used to be focused, for example, in the first one, the principle of procedural economy. Economy. What is economy? Well, to save money many times, but to save efforts also, no? So litigation stages, resources, and procedural cost must be restricted rather than extended. No? You cannot have a very long process if you are able to reduce the stage, the times, the waste of efforts, well, things, no? This is quite clear. What it means? Well, it is a principle and it means so many things. But as a principle, as a guideline, it helps so much. Second, administrative principle of the process. The principle of procedural swiftness. Late justice is no justice. For sure you have heard that. Huh? Everyone has the right to prompt justice in a reasonable short time. You cannot ask, for example, show me I want to have some access to some information, and the state will give you in 20 years. No, there is no right to access to information. No, it should be in a reasonable short time. What it means, a reasonable short time? Well, it depends. It depends on some, but probably never will be a year. At least that the matter is so big and you have so many proofs. Many times nowadays you have For example, in the human rights court process, many times between 3 and 13 years in the Inter-American Court of Human Rights. It's a little less in Europe, I think so. Here, I don't know the times here, but I think that probably it could be not so swift, so short. For this reason, each subject of the process must seek that the final decision is issued with due speed. So it means so many different, depending on the amount, how many parties, how deep is the conflict, and so many things. The principle of procedural relevance. I put the whole principles of the process in the part of communication related to the truth, because the whole process is related to the truth. You will remember now that there were some principles of the message. Between them, among them, it was the principle of relevance. So all of them, all of those principles of timely information, relevance, clarity, precision, and many others applies to the process, applies, all of them. And specifically, when we are talking about the management of the process, well, many times the judge should avoid so many things that are not related specifically to the matter of the dispute. So all the subjects of the process must be focused on the matter of the dispute, not just the judge, but also the parties and also the prosecutor and so many people. All. The principle of procedural opportunity. Well, each procedural act and each act of the parties must be done in a due time. And the principle of registration. All the evidence and all the pleadings should be registered in the process. No? It is quite easy. And then there are another related to the person and property. Well, let's see at least some. The principle of good faith. All parties should participate, act in good faith. In good faith. If not, the judge could punish them, and you know very well this, no? The principle of equality of the parties. Equal arms. You give one right to one, there will be the same right to the other part. If you give one obligation to one of the same, because all of them should have the same arms. The principle of respect. All people should be treated decently. The principle of protection of basic goods. This is quite important in some process. For example, the good of the children, or the good of the marriage, or the good of I don't know, the common good of the. But there many times are some part or some officer, an officer that is trying to see the good of that specific good. The principle of public proceedings, no? Quite important, quite important. Remember all the things that we talk about in the ancient times, in the medieval times, and even in the modern times, no? The tortures in the dungeons and without any public audience. Well, so that is a thing that is good today. No? The principle now is the process will be public, specifically the judgment and some other parts. No, that is quite interesting. Obviously, there are exceptions to protect privacy, honor, moral heritage, professional secret or safety of the people. So, but well, you can read a little more about this. And after that, one question that is, I will just mention here, is the right to appeal a human right? Obviously, you can find in some treaty mention of human rights that mention the right to appeal. But remember the whole theory, no? What is human rights? Well, there should be some reason. Seems to it that the right to appeal, well, is a creation. The whole process is a creation of the mind of the human being. The right to appeal, how can be related to the human dignity, to the, well, obviously there is reasonable, not in all process, all type of process, but when there are important issues, the most important, for example, the penalty, or at least not the first judge will be able to punish you with the death penalty. No, please, at least two instances, 2 stages, and the right to appeal seems to be reasonable in that judgment, and also in another, but related to prison. And that's why the human rights treaties only mention the right to appeal on criminal process, not in any kind of commercial issue, no, in criminal process. That is quite interesting. You can consider a little more yourself. So after seeing the principles, now we will see the test and challenges. We realize that the whole, not more than the principle that we have seen are related to the courts, to the Supreme Court, to the judge of the state. But what about arbitration? Do all the due process principles apply to arbitration or not? That's why I mentioned you have to copy the principles that we have seen today and answer me that. All the due process principles apply to arbitration. And this is quite interesting and will help you so much in your career. It's not a theoretical question. It's a very precise question that will help you. You will see. Let's put another case. Now the case is tennis. I don't know if you know the rules of tennis or if you follow any guy around the world. There is a lot of issues and about the line. The ball seems to be here, that is so clear. The ball is outside of the line, and if the player throw the ball there, will have no points because there are always more. There is another problem here. What about this? If the player will have the points or not in this game, well, it's not so clear. There are some cases that are on the limit. What about this? Well, I think that is clear. Here specifically more clear because there is a shadow and the whole shadow is outside. But in the middle, in the case of the middle, it's not so clear because only if the ball bites the line, the player would have the points. So there are so many issues, no? I mean, let's talk about professional tennis. In professional tennis, I don't know if you know this guy. There's a lot of issues. Well, no, the ball was precisely there. But you have to see, please look at the line. It's precisely biting a little the line. And the other, no, it's not at all. No. And there is a referee, a judge, just for this, for seeing if the ball bites the line. A judge, imagine that, a paid judge, an office, just to see that. That is the only thing that they do. Should Djokovic, this famous player, apply the due process principles? Shouldn't? So that is the question. So at the end of the day, we have three cases. One, the case of the tennis, professional tennis. I mean professional tennis here. Do this poor guy know the law? Second, how can he apply the principles of due process? And second is the arbitration. We have said the courts, the national courts should apply all of them. But what about arbitration? Second question, two questions. What about professional tennis? So now I will open the breakout rooms. Recreate our rooms. Please join your breakout rooms. I will give you 10 minutes. Please answer me if you will apply. You will apply the principle of the due process, and to what extent, to professional tennis and to arbitration. It will help you so much in the career. So 10 minutes, please join your breakout rooms. So let's continue. So what do you think about both questions? No? The principle of due process on professional tennis and arbitration. You should apply it or not? And to what extent? I don't know, for example, the group of Elvis. Are you there?
Yes, Prof. We had a lot of back and forth about the question, but we said that with regards to arbitration, we saw that from the principles, some of the core elements that come out of it is expedition, affordability, and clarity.
Yeah.
And even within an arbitration dispute, these pillars, so to say, are very, very fundamental, and therefore they should also be replicated within an arbitration context.
Yeah.
For the tennis player, hey.
On arbitration, some other principles, there are one that is quite clear.
Aside from the ones I've just pointed out.
Yeah, okay. So, well, let's see what the other people say. Okay, and what about professional tennis?
For professional tennis, we said that especially the principle that discusses certainty of rules, because the players need to know the repercussions for certain actions that they make. So, you know, if probably instead of hitting the ball so that it crosses the court, you throw your racket on the other player, you should know what will come after you.
Yeah. Perfect. Some other group, let's see. I don't know. Faith, I don't know if you what about your group? Did you add any other principle that can be applied for arbitration? Yes, Ali.
I have a question on the arbitration.
Yeah.
How, for us, when analyzing it, the first two pillars apply absolutely. But the third pillar, in terms of the principle related to persons and property, the principle of public proceeding does not apply, because within arbitration proceedings, there are proceedings that are seeking to protect the private legal relationship that exists between individuals within a contractual agreement.
Yeah,
so
perfect.
arbitration is an exception to it.
Yeah. So what do you think, Ali? Most of the principles will apply or not to arbitration? Or
For the arbitration, most will apply except the principle of public proceeding under the principle related to persons.
Yeah, I will say another thing. Yeah. Well, and what about the tennis players? Should they apply?
For the tennis players, yes, because when you look at the linesman who's actually monitoring whether the ball has passed the line, he needs to be fundamentally protecting all these pillars, because he's not only protecting the welfare of the players but also the audience, the spectators. So he also owes a moral responsibility to the whole world to have an impartial sort of judgment and act in good faith. So when we are discussing all the three principles apply for the Chinese linesman. Also, when it comes to swiftness of decision making and the others.
Yeah, that is for sure you need to apply. But for example, in football, soccer, there are many referees that his decision is his decision in the match. Probably many times they are wrong, but there is no right to any appeal. No right to any appeal. Imagine that. So there is not evidence of the parties, not so many things. The decision. So to what extent? Anyone wants to add anything more? Well, don't worry because we are on time. But I will say, and this is the principal idea, and that idea will help you so much in your career. We have to distinguish two kinds of process, two kinds of things that are available, that people can dispose of them. Remember that I told you some minutes ago, and I said this idea will help you to resolve these cases. And there are other things that are not available, that is not on the disposition of the parties. On games, many times, well, you can agree, well, we are bad players, let's agree that we can use also this area outside, and even if the ball falls away, we will just try to play. Not. Yeah, we can agree, because all the rules in games are at disposition of the parties. Obviously, in a professional match, who will put the rules? Well, the owners of the match, of the Champions League, for example, we put the rules for football. Now we will use the VAR or not, and the referee will have the final decision, or the final decision will be. You can put whatever you want. The matter is on your disposal. If not, you cannot touch, and probably you have then to apply the principles of the due process. The availability of the things is the same on arbitration. We can agree on arbitration. Well, this process will be secret, but we can also agree, no, this process will be public. It's a matter of availability. So if you can dispose of the things, because these are these private things, you can do whatever you want. Yeah, and you can change also the rules of the due process. Yeah, because it's in your hands. Yeah, on the other hand, if this is not on your disposition, it's not in your disposition to be the son, the child of your parent, no, you cannot, you have to apply in these kind of things, the public order, the due process, more or less. It will also help you to resolve so many cases, not just those that I showed you to discuss, but also this one, for example. These are indigenous people of my country, Ecuador. Many of them, there are many communities there, approved, I think 23 very large groups, and many of them with their own rules and with their own process and with their own justice. And this is quite important because all of them also are under the Constitution. So what it means, the due process for so many cultures and the one Constitution? Well, it means specifically that there are things that you can apply and then you can change because this could be cultural or not. It's a matter of availability. If it is in your disposition, if you can agree, you can change. If not, no. None of them, for example, will have the right not to give legitimate defense of the parties. No, it is constitutional and they should apply. It is not in their disposition. Other case, a game of cards. No, a game of cards, all is in your disposition. You can change the rule. You can say, well, there will be no innocent people here. All of them will be guilty at the very beginning. You can put whatever you want as a rule, because all the rules of the play are on your disposition. That is not a minimal thing. No? What about the rules of the company? Does a company should apply the principle of due process? Probably in many times, yes. And put, for example, a procedure to fire someone of the company. Well, probably there are at least some minimal things that you should apply. At least a minimal defense, or not, you have to compensate them. So the idea, the exercise of today is quite interesting to resolve so many cases on corporate law, on indigenous people's laws, on games, professional games, and on arbitration too. So as you can see, here you can have a lot of stuff, but it's quite interesting to see how you can extend all the human rights standards to other fields, to companies, to games, or to indigenous people, for example. For today, this is all that I have, and we are on time. Thank you so much. See you next.